What you are about to hear in this video is not merely another routine immigration bulletin, and it is not simply another standard USCIS announcement that surfaces and fades without leaving any meaningful impact. This is an actively evolving legal development within the United States immigration framework that is directly connected to a federal court ruling and a continuing government challenge and internal USCIS directives that have been influencing the handling of immigration applications across numerous categories. If you are presently residing in the United States and awaiting a green card, an employment authorization document, citizenship approval, an asylum determination, or any category of immigration benefit, then this development carries tremendous significance for you because it directly relates to how your application is being adjudicated, or in certain circumstances, why your application may have been stalled from the very beginning. What elevates the gravity of this situation even further is that this is not a concluded determination or a finalized policy revision. Rather, it is a continuing legal confrontation between a federal court and the United States government. And the resolution of this matter could potentially restructure how immigration applications are administered going forward. To comprehend what is transpiring, we need to take a step backward and examine what has been unfolding over recent months within USCIS operations. Numerous applicants throughout the nation began observing atypical delays in their immigration matters. Individuals who had submitted applications for adjustment of status, formerly known as Form E-485, reported that their matters were not advancing at customary speeds. Others seeking employment authorization documents or renewal of work permits encountered unanticipated delays even after completing biometric appointments and furnishing all required documentation. Citizenship applicants similarly reported that their interviews were being postponed or their matters were trapped in background verification stages without any transparent explanation from USCIS. Initially, many individuals presumed this was merely attributable to processing backlogs or elevated application volumes. But as time progressed, it became evident that there was something more systematic underlying these delays because they were impacting particular groups and specific categories of applications in a recognizable pattern. This prompted immigration attorneys and advocacy organizations to examine the matter more thoroughly. And what they uncovered was that USCIS had established internal administrative procedures that permitted the agency to impose what are characterized as adjudication holds on certain immigration applications. These holds fundamentally enabled USCIS to suspend the processing of matters without rendering a denial or approval determination. The difficulty with this framework is that these holds were not consistently visible to applicants. In numerous instances, applicants would simply observe no progression in their case status for prolonged durations without comprehending why their application was immobilized. This generated serious legal and procedural apprehensions because immigration law generally mandates timely and equitable adjudication of applications, and indefinite or unexplained delays can inflict substantial harm on applicants whose entire lives hinge on these determinations. Ultimately, this matter escalated into a federal lawsuit that contested the lawfulness of these internal USCIS hold directives. The litigation argued that USCIS was exercising internal authority in a manner that produced widespread delays without adequate legal justification or transparency. The matter gained extensive attention in immigration circles and is widely referenced in public discourse as the Dorcas ruling. The lawsuit was initiated in federal court, and the matter was examined by a judge in the District of Rhode Island. On June 5, 2026, after evaluating the arguments submitted by both parties, Chief Judge John J. McConnell Jr. determined that there were profound legal deficiencies in how these adjudication hold directives were being applied. The court found that 4 specific USCIS policies were unlawful, including the Global Asylum Hold Policy, the Benefits Hold Policy, the Comprehensive Re-Review Policy, and the Country-Specific Factors Policy. The court concluded that USCIS could not persist in enforcing these directives in their existing form because they effectively permitted the agency to postpone immigration determinations without adequate accountability or transparent procedural boundaries. As a consequence of this ruling, the court issued an order that mandated changes to how these directives were executed. The court vacated and set aside all four challenged policies. The practical consequence of this ruling was that USCIS could no longer depend on sweeping internal hold mechanisms in the manner it had been employing, particularly when those holds were impacting substantial groups of applicants without individualized justification. This represented a pivotal moment because it constituted judicial intervention into internal immigration processing practices, something that does not occur frequently at this degree of administrative specificity. Here at US Updates Hub, I, Timothy, want to ensure you understand the full scope of what the court found. The judge wrote that USCIS had thrown the lives of countless immigrants living in the United States into indeterminate legal limbo by imposing an indefinite suspension on the adjudication of immigration benefit requests for individuals from 39 designated countries and by reopening previously approved benefits based exclusively on applicants' countries of birth. The court emphasized that these individuals had followed all required legal processes. They had filed the appropriate paperwork, paid the mandatory filing fees, submitted to biometric collections, and attended in-person interviews. Yet, USCIS refused to adjudicate their applications. The judge stated powerfully that the rule of law has to apply to everyone equally. Subsequent to the court's ruling, USCIS released an official public statement addressing the determination on June 12, 2026. In that statement, USCIS communicated two critical points that immediately became the centerpiece of immigration discussions throughout the country. First, the agency declared that it strongly disagrees with the court's interpretation and determination. Second, notwithstanding this disagreement, USCIS confirmed that it would comply with the court order while potential further judicial review is pursued. This category of statement is standard in situations where government agencies contest judicial determinations but remain legally obligated to adhere to them. However, for immigration applicants, this generated confusion because it was not instantly apparent whether their matters would commence progressing again or whether the shift would prove merely provisional. This development at US Updates Hub is something I, Timothy, have been monitoring extremely closely because the implications extend to virtually every category of immigration benefit. The court's ruling specifically addressed that the challenged policies had halted adjudication of immigration benefit requests, including green cards, employment authorization documents, non-immigrant petitions, asylum applications, and naturalization applications for individuals from the designated countries. The court found that USCIS had claimed statutory and regulatory authority that it does not possess, made determinations without the reasoned explanations that it must provide, acted without regard for the reliance interests of applicants that it must consider, and justified its actions with pretextual concerns of national security that concealed anti-immigrant sentiments that it is forbidden from allowing to influence its decision-making. In legal terminology, the court declared that USCIS's actions were contrary to law and arbitrary and capricious. Shortly following this development, it is anticipated that the United States government will pursue formal legal action by submitting an appeal. This appeal would advance the matter into the First Circuit Court of Appeals, which would then bear responsibility for reviewing the lower court's determination. The appeal process does not immediately nullify the original ruling, but it permits a higher court to examine whether the legal interpretation and reasoning of the lower court were sound. This signifies that while USCIS is presently obligated to adhere to the district court's order, the ultimate resolution of the policy dispute remains uncertain, because the appellate court could either sustain the determination, alter it, or overturn it completely. This appeal carries enormous significance because it introduces an additional dimension of unpredictability into the immigration framework. On one hand, USCIS is compelled to comply with the court order for the present, which indicates that the internal hold practices should be discontinued as vacated by the court. On the other hand, because an appeal may be forthcoming, USCIS is simultaneously operating under the prospect that the ruling could be reversed in the future. This produces a situation where the agency may exercise caution in how it executes changes, potentially resulting in uneven case processing across different categories and applicants. Consequently, immigration applicants throughout the United States are presently encountering varied outcomes. Some individuals are observing progression in their matters, especially in adjustment of status applications, employment authorization renewals, and certain citizenship matters. Others, nonetheless, are still encountering delays or receiving no updates whatsoever. This inconsistency is not arbitrary but reflects the transitional character of the present framework, where USCIS is endeavoring to comply with a court ruling while concurrently preparing for the possibility that the ruling could be reversed on appeal. In extensive administrative systems like USCIS, such transitions do not materialize instantaneously or uniformly, which explains why applicants are witnessing divergent results depending on their case category, jurisdiction, and processing phase. From a legal standpoint, this matter also presents significant questions regarding the equilibrium of authority between the executive branch of government and the judiciary. The executive branch, through agencies such as USCIS, bears responsibility for executing and administering immigration policy on a daily basis. This encompasses determining how applications are adjudicated, how resources are distributed, and how specific categories of matters may be given priority. However, the judiciary possesses the authority to evaluate whether these actions comply with statutory requirements and constitutional principles. In this instance, the court has fundamentally challenged whether USCIS's internal hold directives exceed permissible legal boundaries, particularly when they produce unexplained delays affecting substantial groups of applicants. The court specifically found that nothing in the immigration statute or the presidential proclamations authorized the challenged policies. The government's position in any appeal would likely center on the argument that USCIS must preserve discretion to administer its workload and render policy-based determinations regarding immigration processing. They would argue that such discretion is essential for administrative efficiency and national security considerations. Conversely, the court's position underscores that administrative discretion cannot be wielded in a manner that generates indefinite or opaque delays without legal accountability. The court emphasized that Congress has established clear timelines and procedures for adjudicating immigration benefits, including the expectation that asylum cases be completed within 180 days and that naturalization decisions be rendered within 120 days of examination. This produces a wider constitutional and administrative law discourse about how much authority immigration agencies should wield versus how much oversight courts should provide. Another consequential dimension of the situation encompasses concerns expressed by applicants concerning fairness and uniformity. The court found that applicants from 39 specific countries, designated as travel ban countries, were disproportionately affected by these internal directives. The court determined that this nationality-based approach violated the Immigration and Nationality Act's prohibition on discrimination in the allocation of immigrant visas based on nationality under Section 1152. The court stated that by directing officers to treat travel ban country-based factors as significant negative factors in discretionary benefit requests, USCIS was effectively penalizing applicants for their nationality or place of birth. This underscores the critical importance of ensuring that immigration adjudication processes are not only legally compliant but also equitable and consistent across all applicants, irrespective of origin. At this juncture, it is essential to comprehend that this situation is not concluded. The court determination has generated a substantial shift in how USCIS operates, with all 4 challenged policies being vacated and set aside as of June 11, 2026. However, any potential appeal means that the legal contest is still continuing. The framework is presently in a transitional stage where USCIS is complying with the court order while also potentially defending its directives in higher courts. This indicates that immigration processing may continue to seem inconsistent in the near term as the agency navigates legal uncertainty and operational modifications. Looking forward, there are multiple conceivable outcomes. If the First Circuit Court of Appeals sustains the lower court's determination, it could substantially curtail USCIS's capacity to employ internal adjudication hold directives in the future, potentially resulting in more transparent and uniform processing of immigration applications. If the appellate court overturns the determination, USCIS may recover broader authority to administer delays and internal processing priorities under its discretion. There is additionally the prospect that the matter could ultimately reach the Supreme Court, which would transform this issue into a nationwide precedent for how immigration adjudication delays are managed across all federal agencies. It is also important to note that the Dorcas ruling does not apply to the State Department's separate January 21, 2026 pause on visa issuances at U.S. consulates for nationals of 75 specified countries, which is subject to a different lawsuit. Until a conclusive legal resolution is achieved, applicants should anticipate continued variability in processing durations and case progression. Some matters may advance more rapidly due to the vacating of the internal hold policies, while others may remain delayed due to administrative backlogs or continuing review procedures. The fundamental point to grasp is that legal determinations and administrative execution do not always progress at identical speeds, particularly in extensive federal systems such as USCIS. In conclusion, this immigration development represents a landmark moment in the continuing legal discourse over how immigration applications are adjudicated in the United States. The federal court has intervened to vacate and set aside 4 specific USCIS hold policies, declaring them unlawful, arbitrary, and capricious. USCIS has announced it will comply with the court order pending possible further judicial review. For applicants, this signifies that applications which were frozen solely because the applicant is from a designated country must return to ordinary adjudication channels. Asylum and withholding applications can no longer be maintained in indefinite suspension based on the vacated policies. Employment authorization, adjustment of status, and naturalization applications must be processed without categorical nationality-based holds. Previously approved benefits may not be subjected to special country-based re-review regimes. For applicants, this means that while there are definitive signs of progression in numerous matters, the situation is not entirely settled and remains subject to further judicial examination. The conclusive outcome of this legal confrontation will not only impact current applicants, but could additionally determine how immigration matters are adjudicated in the United States for years to come. That is everything I, Timothy, have for you on this critical development. Here at US Updates Hub, we deliver all essential visa information and procedures for your U.S. immigration journey. It is vital to comprehend the United States immigration processing steps, visa application requirements, processing timelines, forms, fees, and everything that influences your case. We will continue to bring you all the latest information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas including EB1, EB2, EB3, EB4, and EB5, as well as family immigrant visas covering F1, F2A, F2B, F3, and F4 categories. Thank you immensely for watching, and I, Timothy, will see you in the very next video. If you have not yet subscribed to US Updates Hub, please subscribe immediately and activate that notification bell for more US immigration updates. Share this video with anyone whose immigration case may be affected by this ruling because it could genuinely transform their situation. Reminder, this video is for educational and informational purposes only and does not constitute legal advice. Immigration laws, court rulings, and visa availability are subject to change without notice. Always consult a licensed immigration attorney for guidance specific to your individual case. U.S. Updates. Hub and Timothy are not liable for any decisions made based on this content.